Thank you, Ann.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3005, United States of America versus Alvin Gaskins, appellant. Mr. Hornell for the appellant, Ms. Kelly for the appellant.
Good morning, counsel. Mr. Hornell, please proceed when you're ready.
Good morning, Your Honors. Thank you for giving me this opportunity to present this case to you, and may it please the court. I'd like to start by noting something I didn't include in Mr. Gaskins' brief, which is very illustrative of Mr. Gaskins' relationship, or rather, his total lack of relationship to the conspiracy. On page 18 of the government's brief about the search of the conspiracy stash house, the government wrote, quote, "While Island and Miller deliberated over whether Island should enter the building and speculated about why the police might have been there, Miller offered to send, quote, the faggy over," which was a reference to appellant. This paragraph was disingenuous because the government failed to note that Miller's so-called offer was obviously a joke. Turning to the transcript, Miller said, quote, "Hey, you want me to, laughs, send some unintelligible. You want me to send the faggy? Island, that ain't the unintelligible. Miller, laughs, you, Island, oh God." While the government's mischaracterization of this conversation is suggestive, While the government's mischaracterization of this conversation as suggestive of Mr. Gaskins' involvement should be admonished, the conversation is illustrative. Why would the suggestion of sending Mr. Gaskins to the stash house be so funny to the conspirators? Well, it would be very funny to imagine Mr. Gaskins, the guy that Miller used to pick his kids up from school and take them to sports practice, to suddenly discover a stash house used to cut drugs and count money. I mean, imagine his reaction. I'd like to use my time to highlight a few facts which prove Mr. Gaskins' innocence beyond a preponderance, and even beyond a reasonable doubt. First, in the extensive wiretaps in this case, amounting to over 14,000 phone calls, Frederick Miller and the other co-conspirators spoke explicitly and in code with each other about the conspiracy. When Mr. Gaskins was on the line, they never did this. The government has never proffered an explanation for this, and I've spent hours trying to figure out why this could be. The only reasonable explanation is also the obvious one. The conspirators were hiding the conspiracy from Mr. Gaskins. That's why it's funny to think of sending him to the stash house. They would have no reason to hide this conspiracy from him if he knew about it. Conspiracy requires agreement and specific intent to further the aims of the conspiracy, and neither is possible in the absence of knowledge.
Can I ask a question, Mr. Hornell, which is, why not have an affidavit from Mr. Gaskins? If you have affidavits from others, why not have one from him that would put into the record evidence that from him directly that he was not knowledgeable, did lack the specific knowledge of the object of the conspiracy, didn't have the intent?
Well, Your Honor, it was my understanding that the law made it very clear that a hearing would be required to meet, like I said, the minimums of due process. So we certainly could submit that affidavit. It seems quite clear to me that the judge would simply disregard the affidavit as he disregarded every other affidavit that we submitted. But the reason we didn't submit one is because we assumed that if the motion was denied based on the papers, that we'd have an opportunity to present that information. But we never had that opportunity.
Well, I didn't follow that last part. If the motion was denied, you'd have an opportunity to present what information?
We assumed that Mr. Gaskin would have the opportunity to have an evidentiary hearing where he could testify and be under cross-examination. An affidavit is not a replacement for live testimony.
That's definitely true. I mean, live testimony obviously can be desirable in a lot of situations, but I assume that it's not uncommon, at least, to have an affidavit in addition to live testimony.
Sure, Your Honor.
Is affirmative evidence.
Sure, Your Honor, and we would, if this were remanded and for some reason we're not permitted a hearing, we would definitely submit that affidavit. It's in this case, it's hard to imagine that affidavit moving the needle, given, like I said, all the other affidavits, including an affidavit from an officer of the court being disregarded. So I understand the question, and I appreciate that, and perhaps it was a mistake for me not to include an affidavit in that motion, but nonetheless. Mr. Gaskins, has the right to testify, and having a testimony tested by cross-examination in a live setting would be persuasive, I think, in a way that an affidavit would never capture it.
And Mr. Gaskins did move for limited discovery and an evidentiary hearing before the district court?
Yes, he did.
You mentioned in your brief that you didn't, something like the summary judgment standard doesn't apply, but isn't that exactly what would apply here?
Well, Your Honor, I would love for the court to apply a summary judgment standard. And under a summary judgment standard, the court would have had to take all evidence in favor of of Mr. Gaskins in this case, because he was the one who was basically, summary judgment was found against him. So if the court applied a summary judgment standard, then we would have to have a hearing and with live testimony, because there was the court made credibility determinations based on the affidavits and based on the evidence that was submitted. And frankly, the court took every inference against Mr. Gaskins, which is totally inappropriate in a summary judgment stance. So
I take it you agree that abuse of discretion is the relevant standard here for the district judge's failure to rule on the procedural motion seeking an opportunity to testify and take limited discovery? That would be an abuse of discretion review on our part?
I don't see why it would be in this case. The abuse of discretion standard is there for questions where the court has an opportunity to, or where the trial court has some sort of special knowledge. In this case, the trial court has no special knowledge of in regards to the when it decides everything on the papers. Right. When
I'm sorry, I was talking about just to the extent, so the two separate questions. One is the merits and one is the propriety or not of the district judge having implicitly denied the motion for an evidentiary hearing and or limited discovery. And it's the latter that I was talking about, the district judge's denial of any opportunity to take any discovery and actually put forward evidence. Would that be a legal question, or would that be abuse of discretion, or a combination?
Well, in this case, it seems to me to be a legal question. The judge, in a normal civil case, a judge certainly has discretion to limit discovery when appropriate. So, actually, let me correct that. In this case, or in any case, because a judge has the discretion to limit discovery as appropriate, et cetera, I would say that should be reviewed for an abuse of discretion, because that is, as you said, something that is generally committed to the discretion of the court. In this case, it is clearly an abuse of discretion, I believe, when you have a no evidentiary hearing and no discovery, and then the court makes inferences takes the inferences against the non-moving party, and also when the court makes assumptions about evidence that could be clearly contradicted or easily contradicted by documents that were specifically identified. We identified specific documents that we know are in the government's possession that we didn't get to see, that are very obviously relevant, and there's no excuse for the court to deny us access to those.
And those have to do with, those are the documents about the rental of the apartment. What else?
Well, we did a FOIA request for the FBI's files, and we got some interviews with FBI agents. One of them has a paragraph that's entirely blacked out, except for the one sentence that said, I think it said either Mr. Gaskins or the faggy, I can't remember, will take the blame for everything. But the whole rest of that paragraph is blocked out. Based on a FOIA exemption. And we have no idea what's there, but it seems very likely that the rest of that paragraph is relevant to Mr. Gaskins' case.
On the ultimate merits question about whether the district court was correct in denying the request for a certificate, that is also reviewed for abuse of discretion, I thought, based on our court's decisions, but it sounded like you were suggesting that we shouldn't review it for abuse of discretion.
In this case, I don't think it should be, because it was decided in something analogous to a Rule 56 motion for summary judgment, which is generally reviewed de novo. In this case, there was no hearing. None of the factors that would normally counsel for an abuse of discretion review apply here, because it was decided on the papers. And this court is just as capable as the trial court is of reviewing something on the papers, and so a de novo standard is appropriate.
If there were a hearing, if there had been a hearing, a factual hearing, this would be akin to a bench trial, and then we would be reviewing a district judge's determination of facts and resolution of evidentiary conflicts on the combination of clearly erroneous fact-finding and or errors of law?
Had there been a bench trial, I think that makes sense. That I haven't looked into that much, because that's just not what happened here. But I think that in the case of when you have a review without a bench trial or without a trial at all, you should use the same standard review that you'd use in any civil case where there was no trial, which is de novo.
Mr. Honel, let me ask you something. I've been listening to you, and you're ignoring the elephant in the room, which is our precedent from the 1950s, which every circuit who's had this very unusual statute has relied on and cited. And I don't see how you get over the language that ends with, the sentence that ends with, whereas here, the district judges exercise that discretion. We cannot require him, so on and so forth, except perhaps in a case in which the refusal was completely capricious and without rational basis. That is an enormous bar to clear. And I have not been able to find a case where a plaintiff has been successful in whether, I think a couple have been remanded, but has been successful in meeting this standard. And I find it pretty hard to believe that this is the first case that would clear that bar.
Well, Your Honor, I would say a few things. First, this case doesn't, these cases don't come up very often. They're very rare. So there just hasn't been much opportunity to further develop the law. I mean, that particular case had a very, to me, odd statement where it said that the circuit court shouldn't be or shouldn't force a district judge to stultify himself by certifying an opinion contrary to his belief. To me,
it's not just contrary to his belief. He's the 13th juror, and in this case, this trial lasted 3 months. The jury was out 2 weeks. That's how I read his the court's language. He's the 13th, or the district judge is the 13th juror. He's heard all this evidence.
Well, in this case, the judge heard this evidence and reached a wrong conclusion from it, which was reversed by this court, and a very clearly wrong opinion from it, at least judging by this court's previous opinion.
Well, you do recognize that there's a difference in this area between not proven and innocent.
Yes, of course, Your Honor. But there's no evidence. So in that, for example, in the order the judge made to deny Mr. Gaskins' motion for acquittal post-trial, the judge made these sweeping pronouncements that had no basis in reality, if I can be frank. And the judge, for example, wrote that, excuse me, excuse me, 1 second, please. That it is, quote, "It is pellucidly clear beyond any doubt that defendant Gaskins' actions as a logistical administrator were not legitimate." So when you have a statement that is so sweeping and so completely incorrect, if you don't mind me saying so, especially given the complete absence of any evidence whatsoever that DTI, Dream Team Investigators, was used as a front for the drug ring, as was insisted upon again in this opinion. It's very difficult to see that and say that the judge's previous opinions should be given deference by this court. This trial was in 2004. It's 2019, or it was 2019 when the judge issued his order denying the certificate. And it doesn't make sense to assume that the judge is remembering things accurately from a trial 15 years previous, as opposed to.
I'll tell you something, Mr. Hornell. You're talking to somebody who was a district judge for 4 years, over 30 years ago. And I had one criminal trial that lasted 3 weeks. The jury was out a long time. I remember everything about that trial.
And I don't mean to give any disrespect, of course, to that. But in this case, the objective evidence by reading the judge's opinion in 2019 is that he doesn't remember, because he states that DTI was a front for a drug ring and hardly pretended to be otherwise. There was no evidence whatsoever in that trial that DTI was a front for the drug ring. There was evidence that the only evidence that could possibly be determined to be that way was the fact that Mr. Gaskins arranged the flights when Mr. Miller asked him to do so. But that doesn't make
the bigger question that as I took the district judge to be raising is, where's the legitimate business? And there's the declarations attempt to fill in that gap. And the brief helpfully points out that investigative firms are not only working for government clients, so there might be other clients, but the district judge is looking at a tremendous amount of evidence of illegal drug conspiracy activity, and really saying, come on, use common sense. If the only game in town is the drug conspiracy, then that's evidence that DTI is a front. At least that's how I understood his reasoning.
Well, there's evidence certainly that Miller and the other conspirators got almost all of their money from the drug conspiracy. I think that's true. The question is whether or not Miller used DTI as a drug front, and there's no evidence of that. There's only evidence that that Miller was involved in the drug conspiracy, and that Miller had this business, DTI, an investigative firm that he was building up on the side. And the question is there any evidence that Mr. Gaskins, who worked for DTI, did the taxes, et cetera, knew about this other business?
And did Gaskins also work for the government at the time? Did I pick up that he had some government ID, or he worked for the Veterans Administration? No.
That Mr. Gaskins did?
Yeah.
I don't know. I don't believe so. I think Mr. Gaskins' only income at the time, at least that I know of, was the modest salary he was drawing from DTI. We should also talk about DTI, right? So I would love to have more evidence of DTI's legitimacy, but I was denied access to any of those documents. There are bank statements I haven't been able to see. There was, there were these DTI-related documents that were seized from Miller's apartment and Miller's aunt's apartment, that we should assume those have nothing to do with the drug conspiracy, because if they had anything to do with the drug conspiracy, they would have gone in with all the rest of the evidence.
So can I ask you a question about the relationship between the previous opinion that our court handed down in this case and then the certificate proceeding that we're dealing with now? Is the way that you understand the interrelationship that just by virtue of the opinion we rendered last time, was that in and of itself, including the descriptions in it about the evidence, was that in and of itself something that would have dictated the issuance of the certificate, or
So I'll say,
did something more have to happen?
Thank you. That's a great question. As a general rule, a opinion overturning a conviction for lack of evidence is not enough for a certificate of innocence, right? There has to be more to it. I think this court's opinion does provide enough of a corrective, enough of a statement to say that it does mandate it, right? You can't look at a dragnet of the size that was put around this drug conspiracy, this very serious, very deadly drug conspiracy. It failed to turn up any evidence whatsoever against Mr. Gaskins, and then go on to say, well, it's probably true that he was involved anyway. There's nothing but speculation that would cause that. There's no evidence that would actually believe that. The court's opinion didn't write, there isn't sufficient evidence of Mr. Gaskins' involvement. It said there is no evidence of Mr. Gaskins' involvement.
But what about the putting that in the context of the procedural posture, which is the sufficiency of the evidence to prove something beyond a reasonable doubt? And the notion that it's a sort of a term of art, is there any evidence sufficient that a reasonable juror could have found beyond a reasonable doubt? And you say that once, and then every other time in the opinion, you say no evidence, no evidence, no evidence, meaning no evidence that would meet that bar, whereas it's a completely different bar in the context of the civil determination of innocence.
Sure. I think that the way I read this court's previous opinion, really, it to me used much stronger language than was necessary. And if we're going to be, I don't believe that we should narrow the opinion or narrow the reading of these cases where we say there's insufficient evidence, but then try to take every word completely literally, an opinion that says that the 1950s opinion, for example, that the Honorable Judge Henderson had referenced earlier. The language in this court's previous opinion was far, far, far stronger than would have been necessary to just say, well, there wasn't sufficient evidence. This was too weak to kind of to make a finding beyond a reasonable doubt. That's not what's there in that opinion. That opinion has a paragraph which I quoted in my brief, which says there is no evidence of that puts him in any conversations about drugs, drug money. There's none of the cooperating witnesses had anything. So
let's suppose that we just assume that we disagree with you on that. I know you resist that, but just assume for arguments purposes that we disagree with you on that, and we read it more in the way that Judge Pillard was suggesting. And I don't mean to suggest that Judge Pillard necessarily reads it that way. I'm just saying let's just assume that it's read in that way and through the lens of the beyond a reasonable doubt standard. And so that's what our prior opinion stood for. Then the opinion itself doesn't do the work to give you an entitlement to a certificate at that point, right? Because the burden is on you to prove something.
Yeah, I mean, there's no doubt that the burden is on the person seeking the certificate to prove to a preponderance their innocence. I think it's very important to keep in mind, the possibility of proving this, right? There's no way that anybody could ever disprove, right, their involvement in a conspiracy, right? Because there is nobody there during every conversation that person had. The only way that Mr. Gaskins could prove absolutely that he was not involved is to had walked around with a camera 24/7 for those years and years and show all the video and say, hey, look, it was never there. So we do have to take into account, the possibility. And what we have is we have this constellation of evidence. And so when you look at that constellation of evidence, regardless of what this court said in its previous opinion, when you look at that constellation of evidence, it proves, I think, beyond a reasonable doubt or even beyond a shadow of a doubt that he wasn't involved. You just don't have that kind of investigation and don't turn up any evidence. It doesn't make any sense. You don't have a person who's a administrator for a drug conspiracy, as the government puts him in here, living in a modest apartment with his mother for years. And you don't have a long set of cooperating witnesses who had every reason to throw Mr. Gaskins under the bus, who were facing life in prison. None of them had said he had any involvement in that. And these aren't honorable people, right? these are drug conspirators who are involved in a violent conspiracy. Okay. So we have to ask, why didn't they say he was involved? And I think the only reasonable thing to conclude from that is that he wasn't.
Okay, let me make sure my colleagues don't have any additional questions for you at this time, and we'll give you a little time for rebuttal.
I don't.
Okay, thank you, Mr. Hornell. We'll hear from the government now.
Thank you, Your Honors.
Good morning, Your Honors, and may it please the court. Catherine Kelly on behalf of the United States. Your Honors, in this case, the district court properly denied and did not abuse its discretion in refusing to grant Mr. Gaskins a certificate of innocence because he failed to establish that he did not commit any of the acts charged. He chose, it's important to remember that the burden of proof at this juncture is on appellant to show his actual innocence, which is very different, as the court realizes, from this court saying that there was insufficient evidence of his guilt in the conspiracy beyond a reasonable doubt. Knowing that the burden is on Mr. Gaskins, he chose not to submit an affidavit explaining his knowledge and his intent in this situation, despite the fact that there's no procedure in the statute or, frankly, no legal authority that requires either discovery or an evidentiary hearing in a certificate of innocence proceeding. The courts or the government is unaware of any such requirements. And the few cases that have decided on certificates of innocence indicate that they can be decided on the papers, on the trial record, documentary evidence, affidavits, and so forth that are submitted by the parties.
Did the government respond to the motion for an evidentiary hearing? I didn't see it in the record, and I just want to make sure I'm understanding the record correctly.
But the government did not, Your Honor. It wasn't asked to by the courts, and my recollection is that the court had decided without asking the government to respond. So, Your Honor did not miss anything in the record.
So the government had no objection, it appeared, to the request for limited discovery and a hearing. And I'm just, why would you, typically when a party has the burden of proof, they also have some opportunity to gather information and or have a process for putting that before the court. But it's your reading that this is an exceptional situation in which there's no such opportunity?
My point was, Your Honor, is I have not seen any case law that indicates that discovery is required or that an evidentiary hearing is required, and that, in fact, appellant acknowledged in his district court filings at JA 87 that the unjust conviction statute does not direct district courts to follow particular procedures in determining whether a petitioner is entitled to a certificate of innocence. It's a little unusual in the aftermath of a criminal trial, given that Mr. Gaskins received all the required documentation. There's been no claim of withheld information in the criminal proceedings here, that he would need additional discovery. And frankly, a number of the documents that he cited, particularly the lease agreement and the rental agreement for the stash apartment, Those were publicly available. Those were trial exhibits. The flight information document was also a trial exhibit. To the extent that he attached to his motion for discovery an FBI interview with Mr. Miller, it's clear, even with the redacted information, that it is in fact Mr. Miller who's been spoken to. We have a situation here where, although appellant did not bother to submit his own affidavit, he did get Mr. Miller to write an affidavit for him and submit it. He certainly was able then to ask Mr. Miller, what else did you tell the FBI?
So it seems like your position comes down to that in order to have an opportunity, I mean, one major difference, obviously, between the criminal trial and this civil proceeding is that Mr. Gaskins would have a reason not to testify in the criminal trial, given his Fifth Amendment right, whereas here, once he's been acquitted, he might want to come forward and testify. So it seems like your position is that because he didn't submit his own declaration, that cuts off his opportunity to be heard in person in a hearing. Is that your position, that if he had submitted a declaration, that the district court might have exercised discretion to go forward and hear from him, or not, but that evidence would have been in place, but that given that he didn't do that, he forfeited any, even though he asked for the ability to testify and to get more information, that he's forfeited that by not putting a declaration in the record?
I think so, given the case law that we have, where it's of course appellant's burden to show that he's actually innocent, and in an inchoate crime like conspiracy, that's your best evidence. What is in Mr. Gaskins' mind when you are seeking to get money for an unjust conviction, and the burden is on you, and knowing that the case law does not indicate any sort of requirement for an evidentiary hearing or discovery, it really is incumbent on you, if you're going to support your burden by a preponderance of the evidence, to put forth what was in your own mind.
Right. Well, the case law in our circuit is very, very sparse. Indeed, the case law nationally is pretty sparse. But you do cite the Palungan versus United States case out of the Seventh Circuit.
That's right, Your Honor.
Which does seem to support remanding for an evidentiary hearing in this case, because it was the inverse. There was a certificate grant, but the district court had not yet heard from the former prisoner on his state of mind. And there too, criminal intent was key. And that was a case of I think it was exporting defense articles without a license. And so why shouldn't we be just as willing to vacate a certificate denial for want of the in-person testimony from the very person whose state of mind is critical?
Well, because appellant has already had that opportunity. There was absolutely nothing stopping him from putting his state of mind directly into the record with his own affidavit. Of course, indulgence, I have the Palungan decision here. It was a very narrow question about I believe the question, if I'm understanding it correctly in Palungan, was about whether or not a particular item, which was a rifle scope, was considered a defense article under the statute. And there was some question about its classification and whether or not there would be evidence allowed from the agency about its classification and whether or not it met regulatory criteria. And then if that happened, if there was such evidence from the agency and whether or not it met regulatory requirement, then as a practical matter, defendant could show his actual innocence only by testifying about his knowledge. That's different than what we have here, where really the whole question before the court to establish his actual innocence is what was in Mr. Gaskins' mind. He chose not to tell the court that, and there's really no reason to give him a second bite at the apple.
I don't see how that distinguishes Palungan, which also dealt with what was in the individual's mind, whether he was, someone who had reason to believe that the scope was a controlled article, or whether it was plausible, as I think he claimed, that he thought there was some kind of, embargo to Indonesia or something. But the question is the same in the sense of, we need to have the district court be able to probe and assess the credibility of the person who's claiming lack of knowledge. And, when you actually have that person on the stand under cross-examination, and in Mr. Gaskins' case saying, yeah, I worked for this Miller for a while. And, counsel could say, well, did it surprise you that there did not seem to be very many clients coming and asking for investigative services? Or, and I mean, isn't that just the kind of thing that, were Mr. Gaskins able to testify credibly, the court would potentially be swayed by, and were he not, that one would have more confidence in the denial?
Your Honor, I would just say first that I'm not saying that a court can never hold an evidentiary hearing, certainly, but in this case, kind of similar to the Grubbs case in the Sixth Circuit, the defendant chose not to add that to the record, and therefore the court properly relied here a lot on the trial evidence to make its decision. Appellant chose to put in other affidavits and not his own. And I would also note that twice in his pleadings, Mr. Gaskins said that he believed he had met the burden to obtain the certificate of innocence on the pleadings alone. And it was only if he thought that the court was going to rule against him that he argued that he should get a hearing and the right to discovery. And again, it's simply, given this case, given that the real knowledge is in Mr. Gaskins' head, there was no reason for him not to file his own affidavit, particularly given the state of the law and the fact that there aren't particular procedural requirements written into the law.
Let me ask you, Ms. Kelly, nobody's discussed yet the fact that Judge Lamberth also said there was a failure on this prong about neglect or misconduct. And he ended by saying, although he may have been a limited participant, he knew or should have known. Now, the should have known is what I'm interested in asking you about some of the trial evidence. We said in our opinion, reversing his conviction, although there was substantial evidence of the wealth amassed by other conspirators, there was no such evidence regarding Gaskins. To the contrary, he lived in a modest apartment with his mother. Now, if we take Miller's affidavit in this iteration of this case, that Gaskins, notwithstanding he was a gopher, insisted that Miller prove that this investigative agency was on the up and up. Let's take that.
So we may have just lost Judge Henderson's audio, and to make sure she was in the middle of a question.
Paints a picture of Gaskins as
all right.
Can you hear me?
I can hear you now.
We
can hear you now, Judge Henderson. I think we lost you there for just a minute.
Okay. Well, did you hear me talk about Miller's affidavit?
It was going in and out, Your Honor.
Just started to talk about it, but then didn't hear the
all
rest
right.
of
Well,
it.
Miller painted the picture, and I don't know what's wrong with my internet again, but painted a picture of a gopher being very punctilious to the extent of insisting that he prove that the business was on the up and up. So my question, I guess, from the trial evidence is this substantial evidence of the wealth amassed by the other conspirators. Is it reasonable for someone like Gaskins, who made a big deal out of making sure this was a legitimate business, to think that that investigative agency would support the lifestyle of his co-conspirators?
Your Honor, I think the fact that Mr. Miller said that Mr. Gaskins essentially required him to prove that DTI was a legitimate company really informs the fact that shows that Mr. Gaskins was indeed suspicious of DTI. And if he's going to the length before he takes a job to ask the person who offers him a job to show that it's a legitimate company, that tells you boatloads that he's suspicious.
Well, what about the substantial evidence of the lifestyle of the co-conspirators? Have you looked at the trial evidence in that regard? I mean, what was put in?
I recall there was trial evidence about how much money was being obtained, how much, particularly the heroin was in the, 5-figure numbers as far as how much it was worth when it was bagged and so forth. I believe there was one cooperator who was talking about having a lavish lifestyle. But I don't think that it really answers the questions to say Mr. Gaskins got $600 a week for his input into the conspiracy. It's not clear that the fact that he made less than other conspirators, for instance, means that he was not a participant, a knowledgeable and active participant in the conspiracy.
Well, I guess what I'm really asking is this: is it reasonable if you assume that Mr. Gaskins did all this investigation of the agency first, and in the face of substantial wealth of all these people he was dealing with, he still thought, well, I'm still suspicious, but I'm not going to do anything about it? That's the should have known part of the prong.
Correct,
That's
Your Honor. And I don't think it's reasonable for him to say that I'm seeing this wealth and it doesn't raise my suspicions, particularly when you look at it along with the other evidence. He had a drug sale of his own to Mr. Briggs, who was a conspirator in this case. So this isn't somebody who was a babe in the woods who knew nothing about the drug trade. The nature of the flights that he was booking, they were last minute, they're short turnaround flights for Mr. Brown, who ultimately was a money mule, for lack of a better word, for the conspiracy. He's subscribing to these cell phones, which are now claimed to be for DTI's business and for Mr. Miller's business, but it's highly unusual for an employer to say, you're going to, perhaps you order the business phones, but you don't do it in your own name with your own social security number and then just hand them off to the other folks.
So does it matter? I mean, this is a curious position to be in, but let's say you were the district judge, and I just wonder how much the formalities matter. That the flights that Gaskin booked were by as you say, a money mule, but the drug money there was not from the drug of which Mr. Gaskin was convicted. So there's he was convicted of a heroin conspiracy, even though the broader conspiracy, the conspiracy charges generally were a number of different drugs. But if that, if Brown, and I don't remember whether it was PCP or, the money coming out of that locale wasn't heroin money, does that matter? How formal, the evidence that comes the closest to saying Mr. Gaskin might have been putting his head in the sand, if those close, implications of, come on, guy, you should be backing out away from these people, are not the thing that he was charged with, does that prevent him from getting a certificate of innocence? Or
I think you can look at all the evidence in deciding whether or not to grant the certificate of innocence. And one of the prongs under the statute is that he has to show that he did not commit any of the acts charged, and that he didn't by misconduct and neglect cause or bring about his own prosecution. So here he was charged with conspiracy to distribute heroin, PCP, crack, and powder cocaine. And it was his neglect, at the very least, that caused his own prosecution. He hid his head in the sand at the very most, and that's assuming he didn't know already what was going on. He had his lease name on the lease for the stash apartment, on the rental application. There were utilities in his name for that apartment and so forth. And the court will recall too that there was a lot of evidence at trial that although DTI was holding itself out as a defense investigation agency, Mr. Kramer from the Federal Public Defender Service testified that 90% of the folks who are criminal defendants in DC are CJA eligible, and that there were no funds given to DTI or any of the conspirators.
So this line of argument on the neglect prong, that wouldn't succeed in the way that the Seventh Circuit looks at the neglect prong, right? It's contingent on looking at the neglect prong in a different way.
That's correct, Your Honor. And we would respectfully say that the Seventh Circuit reads that too narrowly, that the Graham Court and the Fourth Circuit got it right, that you can look at the evidence at trial and so forth. It's just not a matter of,
and
you have to take a material step to, for instance, I think that case was making a false confession in order to create your own situation.
Right. So we have different courts of appeals that look at this prong differently, at least as it stands right now, one of which would be in your favor and one of which would not on this prong. And can I just go back to the other prong for one last question? And there's one line in the district court's opinion that was interesting to me, and this is on page 105, JA 105, at the end of the first full paragraph. And this is after having gone through some of the indications about whether Gaskins would have known that he was involved in an enterprise that had an illegitimate object. And the district court caps off that paragraph by saying, the burden of proof belonging to Gaskins in this action, this argument does not persuade without more affirmative evidence. And on the without more affirmative evidence part, and I suppose one potential response to that is, well, there could have been more affirmative evidence if the motion for an evidentiary hearing would have been granted, or some discovery would have been allowed, or some combination thereof. And then you've got your point, which you made in your brief and you've reiterated this morning, to the effect that, well, there could have been more affirmative evidence had an affidavit been submitted by Mr. Gaskins. And I'm just wondering what we do with that line, given that the district court itself seemed to contemplate the possibility of more affirmative evidence making a difference.
I would just read that, Your Honor, as saying that Mr. Gaskins did not meet his burden of proof, even after saying twice in his pleadings that he thought that he had presented enough evidence in his pleadings alone to get a certificate of innocence.
But that's an alternative argument. I find that a little harsh in the sense that, he looks at this opinion, which does involve very far-reaching investigation, many cooperators. And if the prosecution really were dotting its I's and crossing its T's, it would have had one of those cooperators expound on Mr. Gaskins' role. That didn't happen, right? And as I was saying to Mr. Hornall, the no evidence has to be taken in the procedural posture. But nonetheless, there's, the Court of Appeals does say no evidence. So first line of argument on their part, the acquittal for insufficient evidence alone is enough. Second line of defense, which the government never opposed, is give us an opportunity to collect and put in evidence. What's wrong with that?
Just simply that the burden was on him, and based on the existing case law, there is no clear right to an evidentiary hearing or to discovery. And in addition to that, it's simply a matter of when you don't choose to put in evidence, then you're stuck. If you make that decision, then that's that. He had the best evidence in his own mind.
But is that the choice he made when he asked for discovery? That's not the choice he made.
Frankly, I just don't see what is going to happen in discovery that is going to show his state of mind. I believe that there's just no way and I think Mr. Hornall said this in his own argument a while ago, there's no way to disprove his involvement in the conspiracy. So I frankly don't see what's going to happen if you get a document dumped from the government to show that Mr. Gaskins did not act as a logistical support who was arranging things that were not him touching the drugs for the conspiracy. So I frankly don't see, when you look at the items he attached to his motion for discovery, it's stuff that he had at his fingertips already. They were exhibits from trial. It's information that he wants more information about what Mr. Miller said to the government. Ask Mr. Miller, you got an affidavit from him. You certainly know how to find out what's in Mr. Miller's mind.
Ms. Kelly, is it not, it seems like it's possible it's an abuse of discretion for the district judge to not even mention, acknowledge, or rule on the motion for limited discovery and an evidentiary hearing.
I think it's just implicit in the court's decision that it was denied. I don't know that the court needs to mention that. It's quite clear that the court denied it. I'd note one other thing too, that Mr. Hornall has mentioned this as being akin to a Rule 56 proceeding, and there's simply no certificate of innocence case law that indicates that getting a certificate of innocence is a Rule 56 proceeding. There's one court that actually said it. I believe it was the Abu Shawish decision in the Seventh Circuit, said it's more like moving to get your seized property returned to you under Criminal Rule 41G. But even if you're going to have a Rule 56 proceeding, this court said in the Pollock decision that if you're claiming to need discovery for summary judgment proceedings, you have to put in an affidavit explaining why discovery is needed. So once again, you have a situation where appellant would have to put in his own affidavit saying, this is why I need discovery in this case. Because frankly, in this case, he's trying to say, I don't know what was in my own head, which is of course ridiculous.
Okay. Let me make sure my colleagues don't have additional questions for you, Ms. Kelly.
I do have one out of Rigsby, and that is this very high bar that our court has set with the use of the word stultify. And if you look at that paragraph, the court, it doesn't limit it to the presiding judge, but it is the presiding judge in that case. And there are going to be times, and I think some of those other cases, at least one of them had a district judge reviewing a certificate of innocence who had not been the trial judge. But here, Judge Lamberth had been the trial judge. And so our court set at least an extremely high bar where the judge had been the trial judge. Do you see any lessening of that if he hadn't been? In other words, the use of the word stultify, you can see the panel saying, this trial judge sat through 3 months, jury out 2 weeks. He listened to all the evidence, and we're going to say, notwithstanding we're reversing it, that it's been reversed, we're going to say that he's got to certify that the defendant is in fact innocent and had nothing to do with his prosecution, except, and the bar is that we're going to say only if perhaps the trial judge was completely capricious and without rational basis in denying it. I don't know that I've ever read a standard of review that's that high.
No, it's extremely high. In fact, if I recall correctly, the Rigsby court had even questioned for a moment whether or not there could be appellate review of the denial of the certificate of innocence, and then came to the conclusion that it would review for abuse of discretion. As Your Honor had said earlier, the trial judge here was in fact sitting as a 13th juror when he was looking at the certificate of innocence evidence before him. And it was a very lengthy case, and And I would also note too that this is not a case where there's really a concern that the district court has forgotten the facts. I believe Mr. Miller, within the last 6 to 9 months, was resentenced for a third time in this case. So this is not a case that went away in 2006. It's still living in some manner in the district court today,
All right.
or at least
All right.
until
Thank you.
recently. Thank you, Your Honor, for all the reasons we've stated, and given particularly the evidence at trial, we respectfully request that you affirm the decision of the district court. Thank you.
Thank you, Ms. Kelly. Mr. Hornell, we'll give you 2 minutes for your rebuttal.
Thank you. There's a lot to get through. I'll get as fast as I can. Let's first turn to the case Abu Swawish versus United States in the Seventh Circuit. The district court in that case denied a petition for certificate of innocence without giving the petitioner an opportunity for the hearing. And the circuit reversed and held that the court was required to conduct a hearing on the evidence. And I note that in my reply brief. It's also, as I mentioned in the brief several times, a minimum of due process, the right to a hearing when there's going to be a deprivation of property. And in this case, there's a very severe deprivation of property. There's a lot of money at stake.
We do summary judgment back and forth all the time without a live hearing.
Sure, of course. But in that case, you take all of the evidence in the favor of the non-moving party, which the court did not do in this case. So if we're using that standard, then you'd still have to remand. I'd like to talk a little bit about the standard of completely capricious and without rational basis. I don't believe that is the standard of review on these cases. But even if it is, Mr. Gaskins meets that. It is completely capricious to refuse access to evidence when evidence is available and when it has been shown to be available. For the government to say that Mr. Gaskins can just ask Mr. Miller what he said in this interview and then put that into an affidavit, that's not credible evidence. That's not going to be accepted by the court. It was completely capricious for the district court to say the DTI is up front. There is no evidence the DTI was up front. None. The only evidence that it was mentioned, which is that they didn't apply for CJA reimbursement, was already called by this court hardly substantial. And for it to pin an entire theory of case on something that the appeals court has already said is hardly substantial is absolutely capricious. The argument about the substantial wealth of others in the conspiracy, I'd like to point out that my understanding is that is for the others who are not Miller in the conspiracy. I believe Miller was sort of like a middling figure in the conspiracy, as opposed to the others who did have an awful lot of money. And that's something that needs to be developed at trial with evidence. If we're going to talk about these things, trying to shoehorn it into a short argument at the Court of Appeals when you didn't even get a chance to do it at trial is not a fair procedure and not reasonable and not likely to result in accurate fact finding. Going back to the utility and the rental agreement, one of the documents we got through FOIA that we would not have gotten otherwise was this FBI fingerprint report. The fingerprints of Mr. Gaskins were not found on the rental agreement or the utility bills. Other people's fingerprints were found on those bills.
So I'm not aware, Mr. Hornell, you've emphasized the desire to have the case reassigned to a different judge, but I'm not aware of any case anywhere in the country in which a certificate of innocence issue was remanded to a different judge. Are you?
I'm not aware of it. Again, there's so little case law in here, I wouldn't expect to find that. So we apply the standards that are typically applied in these cases. And when a district judge has shown resistance to a circuit court's very clear corrective and made statements, a number of statements in his opinion, which are not factual, which are contradicted by the record, and he just makes those statements and he shows no interest in hearing from a defendant. If you had an open mind, if a judge had an open mind, a judge would want to hear from that defendant and let that defendant be tested by cross-examination. The judge would be interested in seeing this new evidence. The fact that the judge had no interest in seeing this evidence and writes this opinion, which is, frankly,
well, he looked at the evidence that was put in, but not the evidence that wasn't. So on what authority would we order the district judge to have a hearing rather than simply remand for him to consider the question of how evidence might be amassed?
I'm sorry, I don't understand that question.
In other words, you've asked for us as in the alternative to remand for an evidentiary hearing. And I guess my question is, what's the authority on which we could specify the process, hearing versus papers?
I believe that the Seventh Circuit in Abu Swamish versus United States did just that. The circuit courts have an inherent right of supervision over district courts, and in this particular case, it's very clear that the district court's refusal to hold a hearing and refusal to allow access to evidence, which we have pointed out, we know this evidence exists. We've attached the redacted copies. We suspect there's significant more that we weren't able to get to the FOIA process, but we don't know. The district court or the circuit court can certainly order the district court to follow procedures that comport with due process.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Hornell, before we.
No.
Okay. Thank you, counsel. Thank you to both counsel for your arguments this morning. We'll take this case under submission.
Thank you so much, Your Honors. Really appreciate this opportunity.
Sri, I can call. I know how to call in, so I will call in the number.
Ah, got it. After this, after our next case. Yeah.
Right.
Perfect.
Case number 20-1212, Delaware Division of the Public Advocate et al. Petitioners versus Federal Energy Regulatory Commission. Ms. Roberts for the petitioners, Ms. Benta for the respondent, Mr. Flynn for the intervener.
Morning, counsel. Ms. Roberts, please proceed when you're ready.
Good morning. Thank you. May it please the court, my name is Casey Roberts, appearing on behalf of petitioners. This case is about the Federal Energy Regulatory Commission failing to do its job of protecting consumers from paying excessive rates for electric generating capacity. For years, PJM's capacity auction has forced consumers to pay prices higher than necessary to attract sufficient investment in capacity and also to buy far more capacity than needed to meet the reliability standard. When given a chance in this case to set a course that would alleviate those unnecessary costs, the Commission instead approved a demand curve that will result in nearly $100 million in excess costs each year. Petitioners assert three errors in the Commission's orders. First, approval of the greenfield combustion turbine as the reference resource. Second, approval of blanket application of the 10% adder in modeling energy revenues of the combustion turbine, which further increased the amount consumers would need to pay for capacity. And third, the Commission's decision that it need not consider oversupply in determining whether the filed demand curve would result in reasonable rates. First, FERC erred in approving PJM's decision to use the greenfield combustion turbine as the reference resource. The greenfield combustion turbine is not an accurate representation of the cost of building new capacity in the PJM region. The record shows that cost is estimated to be 25 to 63% lower than the cost of building the new greenfield combustion turbine. A demand curve based on a combustion turbine will, in the estimation of PJM's own consultant, perpetuate PJM's chronic excess capacity at a cost to consumers. Commission's approval of PJM's choice of reference technology does not hold up under the three-part test that FERC has applied in two recent ISO New England orders to the same question. Under that test, FERC considers whether the proposed reference resource is likely to be built, whether its costs and revenues can be estimated accurately, and whether a curve based on that resource will procure enough capacity to meet the reliability standard, but not so much that consumers pay unnecessary costs. There's no evidence that a greenfield combustion turbine is likely to be built in PJM. None have been built since 2014, a time period in which roughly 27,000 megawatts of new combined cycle capacity has cleared the auction. FERC points to two brownfield combustion turbines that have been developed since 2014, but the construction of these cheaper facilities at existing sites does not show that a more expensive greenfield combustion turbine is likely to be built in the future. FERC leans heavily on theoretical advantages of combustion turbines, such as lower total cost and quick deployment. But these theoretical benefits are belied by the decisions that developers of new generation have made over and over again in recent years. Likely to be built must mean more than theoretically possible somebody could want to build it for the demand curve to reasonably approximate the cost of new entry, as FERC has repeatedly held is critical to this type of inquiry.
Can I ask you, Mr. Roberts, it seemed like part of the commission's rationale on this score had to do with the reliability and the reliability of the alternate baseline that you would propose. What's your response to that? Because that seems like certainly a reasonable consideration to take into account.
Yeah, so the commission did sort of repeat PJM's assertion that there were misestimation risks associated with using a combined cycle resource as the reference resource that could result, I think they said, in specific reliability risks. However, what FERC was citing to there was PJM's sort of cherry picking of certain evidence from the record. We provided and pointed to evidence in the record that other curves based on the combined cycle resource would in fact meet reliability, even accounting for some risk of misestimating the net cost of new entry. And FERC never addressed that evidence that we pointed to, which undermines the conclusion that it reached, and that's not, reasoned decision making.
But I thought, at least in the Brattle report, that Brattle had a number of different models. Are we talking about the combined cycle curves, and that the other curves also had some issues in terms of reliability? They didn't necessarily perform better or meet the target. There was one I thought that maybe did, but most of them had issues as well.
Yeah, so Brattle evaluated 2 curves based on the combustion turbine and 4 curves based on the combined cycle. And then each of those had sort of other parameters being adjusted. And 2 of the 4 combined cycle based curves that it evaluated would meet the reliability standard of no more than 1 in 10 outages on average, 1 outage in 10 years on average. And both of those curves, that was curves C and D, met the reliability standard, even if their net cost of new entry was underestimated by 20%.
But the C curve, it performed okay in terms of reliability, but it was still short of the curve that PJM preferred and that FERC approved, right? Which was the B curve, the combustion turbine based curve.
Yeah, that's correct. Curve C and curve D, which are the 2 that met the reliability standard, were not, I guess you could say, quite as reliable as the B curve. However, both of them exceeded the reliability standard that FERC has set out in these cases. They both have less than the 1 outage in 10 years. And so we contend that where a curve, these curves exceed the standard, and FERC hasn't justified why consumers should be required to pay costs above what is needed to meet the reliability standard.
And isn't it the case that the C curve was also one of the ones that didn't eliminate that rightward shift that everybody seemed to want to get rid of? So that's
correct.
That also, I mean, so we're talking here more like $250,000 rather than the 100 million that your briefing focuses on. That the difference between the B curve and the C curve is much smaller.
Yeah, that's correct. I can't remember exactly what the savings were, but what you suggest sounds about right. So. Yeah, the savings increase, from the C curve down through the F curve, but I'm sorry, I think I forgot your your question relating to that.
No, just that it's a narrower perceived benefit in terms of potential cost and forgoes some other benefits to consumers. To go with the CC curve, the alternative. So
sure, yeah, I understand.
Trying to get the factual coordinates, but it's really an observation more than a question.
Okay, thank you. I would just add that should if the commission were have to decide that a curve based on a combustion turbine was not just and reasonable, then I would expect PJM to have reconsidered and maybe looked at more candidate curves based on a combined cycle to sort of test different options and combinations of parameters. All right. There's no evidence that a greenfield combustion turbine is likely to be built in PJM. excuse me, sorry. So next, FERC failed to respond to evidence that the costs and revenues of the combustion turbine cannot be determined with confidence, the second factor in the ISO New England test. PJM's filing shows that there is inadequate market data to estimate the future revenues of combustion turbines. Petitioners pointed to this evidence both in our protest and on rehearing, but FERC's orders did not address this evidence, which is squarely on point. Instead, FERC focused on why it might be hard to accurately estimate the revenues for a technology that PJM did not propose to use, the combined cycle gas plants. But there again, FERC fails to address evidence contradicting its position. PJM's own consultant specifically disagreed with the conventional wisdom that combined cycle resources are subject to more estimation error. Petitioners pointed FERC to this other evidence in our request for rehearing, but FERC failed to respond. This does not constitute reasoned decision-making as required by the APA.
Well, so the logic, though, is that it's harder to estimate the revenues from combined cycle because more of them rely on the real-time energy markets, right? The day ahead and the real-time energy markets, which have yet to occur. Those are going to occur years hence. So it seems intuitively accurate, especially when we're talking about capacity markets, which are insurance against exceptional energy market conditions. So everything's going to be haywire by the time the capacity that's being auctioned today is in use. So maybe the energy markets are going to be more volatile in that context, and any technology or any reference resource that is more reliant on those energy markets, you know, for the net, for the cone, kind of by just the logic of the situation is going to be more harder to estimate, harder to pin down. No?
Well, so what I would say is that the amount that developers are willing to offer into the Capacity Auction Act reflects their anticipation of what energy revenues they will earn. And the Brattle said that was very, very hard to predict for combustion turbines, right? And even though PJM and FERC both state that, oh, well, combined cycles are more reliant on energy revenues, so basically any error is very consequential. In fact, the record shows, and PJM pointed to this in its transmittal letter, that combined cycles rely on energy market for 61% of their revenues, but combustion turbines rely on it for 27%, which is, you know, only half as much. And so this is where FERC really failed to engage in reasoned decision-making when looking at if the consultant is telling you it's very hard to develop accurate energy revenue forecasts for combustion turbines, it's quite easy to do it for combined cycles. That it doesn't follow that, well, combined cycles, therefore, you cannot estimate their net cone with accuracy, because the difference between the extent to which they rely on those energy revenues is really not quite as stark as PJM presented. The Commission did not address the third and most important factor in the ISO New England test, whether PJM's choice of reference technology would result in unnecessary costs for consumers. Failure to examine a central issue presented, especially one that ties so closely to the Commission's core duty to ensure just and reasonable rates, renders its decision arbitrary and capricious. In its brief before this court, FERC has no answer for this oversight. The record shows that selecting a combustion turbine as the reference resource would lead to higher prices and more capacity than needed to ensure reliability, compared to another curve based on the combined cycle reference resource, which we were discussing a minute ago. Petitioners twice pointed FERC to this evidence, but the Commission does not respond to either the evidence or petitioner's argument. So I'm going to go ahead, and if there are no further questions at this time, save the remainder of my time for rebuttal.
Let me just ask you, you opened talking about ISO New England, but has FERC treated that as a sort of generally applicable test? I'm not aware of it applying that particular analysis other than to ISO New England.
Yeah, FERC has not expressly applied that test to PJM. The test was developed first in a 2014 order and in ISO New England, and then reaffirmed in a 2017 order. However, the question that's being evaluated by FERC in those ISO New England cases is identical to what's being evaluated in these PJM cases. And like cases should be treated similarly without an adequate explanation for differentiating among them. And so we see no reason why the ISO New England test and those 3 criteria should not apply to the exact same question when evaluated in the PJM context.
You also emphasized repeatedly that PJM used a greenfield combined turbine facility rather than a brownfield one to calculate the costs. But the site isn't really part of the definition. The site is, affects the net cone, but not the reference resource. And that seems like that would require a distinct challenge. You've challenged the choice of reference resource. So I just wonder whether the site, which affects the net cone, is actually in this petition. Is that properly before us?
Yeah, I understand. So the reason that we focused on the fact that FERC approved a greenfield combustion turbine is that the costs of that combustion turbine are more than those at a brownfield site, right? So there's a cost of gas and electric interconnection, there's cost of buying land, and those additional costs take it even further away from what we see is the actual cost of new entry in the region, which over the past 5 or so years has been 50 to 80% lower than what PJM's administrative net cone had been. And so that takes you even further away from the benchmark that FERC itself has set out in these cases, that this administrative net cone value is supposed to accurately represent the true cost of net entry, of new entry in the region.
Okay, unless my colleagues have additional questions for you, this time we'll hear from the commission and interviewer. Thank you, Ms. Roberts. Ms. Banta.
Good morning. I'm Carol Banta for the Commission, and I'll begin with this last discussion of the New England cases. In particular, looking at the 2014 case, one thing to remember about those cases is that New England, like PJM, has, the Commission said, the tariff does not prescribe how they need to select this resource. And so New England came in and said, here are the factors that we considered. And then in the paragraphs that the petitioners have cited, the Commission said, yes, your analysis makes sense to us. Now, to be clear, New England came in under Section 205 with its own proposal, to which the Commission has what this court has called a passive and reactive role. So in PJM, which also has no prescription in its tariff for how to make this decision, PJM came in with its own discussion of here's what we propose, here are our reasons for it. So the Commission said, sure, we'll look at the New England factors because they are similar considerations and they are accounted for in this case. But as far as the question of whether that's some kind of binding precedent, there's nothing in the New England cases where the Commission purports to set forth a test that it will apply broadly to every system operator. And indeed, it was echoing New England's own Section 205 filing, which the New England operator was within its statutory rights to make, and the Commission was considering that proposal. In this case, the Commission is considering PJM's proposal and whether PJM adequately supported its case. Now, I want to point to where the Commission started its analysis in the very beginning of its substantive discussion in the curve order, which begins at paragraph 16. I begin with cost to consumers because that's what the Commission in fact did. The Commission started its analysis in paragraph 16, and it echoes it again in paragraph 20, which is the first argument that it considers in this case, with the focus on cost to consumers. And the language in paragraph 16 on JA 298 is in the second sentence. We find PJM's proposed changes result in a curve that meets PJM's reliability needs at a reasonable total cost to load. Load means end users, it means consumers. And I'd point out that reliability needs are not merely a concern of cost to suppliers. Reliability is a consumer interest as well. And one of the Commission's primary statutory responsibilities under the Federal Federal Power Act, in addition, of course, to just and reasonable costs. and what this court has held many times, including in particular in advanced energy, is that there is a balance. That sometimes in advanced energy, providing reliability under PJM's 205 proposal in that case was going to cost more. And it was a balance of reliability versus perhaps costing more. And is that a just and reasonable cost? And this court said in advanced energy that the commission in approving PJM's proposal had made that balance and had shown that balance. So looking at paragraph 16, the commission starts by saying we find this reasonably balances reliability and cost. Then we look at paragraph 17 where it's summarizing the beginning of PJM's case for its proposal. There's no dispute in this case that PJM's proposed changes lowered the prices of capacity. It lowered the costs. It not only did the shift to the left, or undid, I should say it undid an escalation of prices that had been put in place in the previous, I believe, 2014. It undid that 1% shift to the right by shifting to the left. That alone brings the curve down. Also, the changes it made all but one of which, or most, I should say, all but two of which in this case are not contested on appeal, brought that straight line. If you look at the commission's brief at page 13, has the previous curve and the revised curve. It brought that flat line down before the curve even begins its descent at the target margin. That's things like using the H-class turbine instead of F-class turbines. That was hotly contested below. That's not before the court on appeal, but that made a big difference in cost. The other changes to labor costs, cost of capital, various things, all these other changes, there's no dispute that they brought the cost down. So petitioner's argument here is that the cost should be even lower and that PJM is being too conservative about reliability. So that's the balance that was in front of the commission that's also on the 205 proposal from PJM and is also before this court. So then in paragraphs 18 and 19, the commission lays out the public interest entity's argument that the existing curve has been producing oversupply. And in paragraph 20, it again echoes the language about reasonable cost to load, because it says PJM's analysis in its 205 filing is sufficient to meet the requirements of its tariff, which is designed to ensure that the proposed VRR curve meets PJM's reliability needs at a reasonable cost to load. And what's important about paragraph 20, when it says the requirements of the tariff are designed to ensure this, we're talking about the larger capacity market mechanism, which is not presented in this case, either to the commission or to the court. The capacity market mechanism is previously approved, most recently in advanced energy. And this is just the inputs to one part of it. And the commission says that PJM has supported the changes it wants to make to the inputs to this one aspect of the market mechanism. So if the asserted problem here is that the market mechanism is resulting in a chronic oversupply, the answer to that is to bring a challenge under 206 to the market, to the larger market mechanism that's previously approved. That's not an issue in this case. What was before the commission in this case is, did PJM adequately support, with evidence and its own explanation, the changes that it wanted to make to the inputs and its reasons for making them and why those are reasonable? It didn't have to exclude every other possible method, although PJM did go ahead and explain why it wasn't changing to the combined cycle, and the commission considered PJM's points in that regard.
Ms. Banta, can you talk about the 10% adder? And I don't know, I did not see in the record, I think the Brattle report said it was mixed and inconclusive, but do you know how often in practice the combustion turbine offers into the energy market actually use the 10% permission, the 10% adder? Because it just struck me that just because it's authorized wouldn't necessarily, just as a sort of a logical matter, wouldn't necessarily support including it as if every generator used it. Maybe 20% of them use it, in which case maybe it should be a weighted portion of the 10%. So it was curious to me that I didn't see any information about something that I gather is optional with the generator, how frequently it's actually used, as to sort of, because I gather the whole inquiry here is accuracy when we're talking about trying to calculate the net cone and do that in terms of subtracting revenues.
I think the only data we have in the record is Brattle saying we just don't know. Some companies use it and some don't. Mixed reactions on JA 146 was exactly what Brattle said.
Yeah.
And so in trying to determine the price of a hypothetical resource, the reference resource is a hypothetical resource with the cost that we know. I think what the commission said is, given that, I think as the commission says, the offset calculated or estimated for the energy and ancillary services offset reflects all eligible offer cost components. And so the commission just made the judgment that because the 10% is provided in the tariff and was previously in a different case, not at issue here, determined to be just and reasonable, we don't see a reason to exclude a component that the tariff permits.
It seems perverse, though. I mean, just because it's permitted doesn't mean it's used. And if the inquiry, or if the project, once we're looking at trying to accurately assess cone is accuracy, it seems like it's an unnecessary distortion. I mean, unless that information is just not obtainable, that what I would want to know is, what is the experience of combustion turbines in the energy market? How frequently do they take advantage of the allowable 10%? And how frequently they say, no, I'm not going to do that because of least cost dispatch. I'm not going to take advantage of the allowable 10% because that's just going to put me to the back of the line. I'm not going to be able to sell the energy I have. So is that information that's not available to the commission? Not for some reason wouldn't be accurately predictive? Like, why isn't that information obtainable? And I thought Brattle, in fact, gave a nod to maybe you should get that information.
Right, and I think Mr. Flynn might be able to answer some of that. I know PJM argued in its brief that it would be difficult to model. One thing I would point out, the hypothetical reference resource is chosen for the entire region. The curve is done a little differently, and the markets are run differently in some of the sub-regions. And I do believe that there are some parts of the PJM region where, for instance, access to gas supplies is different than in other parts. So I'm not sure whether that plays into the ability to develop a uniform number. What we do know from this record is that combustion turbines, the reason that goes into why they are particularly responsive to capacity market revenues, they don't make most of their money from the energy market, unlike combined cycle. Combined cycle costs a lot more to build, the fixed costs, and then makes up to 60% from the energy market revenues. The combustion, and I just wanted to give a couple of JA sites without belaboring the numbers, but JA 107 and 108 have the costs that Brattle came up with that show you the 300 million for the combustion turbine versus the billion for the combined cycle. The combustion turbines, they're cheaper to build and they're faster to build, which is why they're more responsive to market signals, but they don't run as often.
Right.
They're peaking, right? So I think they tend to run.
Their revenue numbers were, I mean, again, it's only one component, but their revenue numbers were substantially affected by the 10% assumption. Taken down by like a third, I think, or
right, which of 27% would be about 9% of their total cost. But and so I don't have a number on. I just, since we do know that they don't run as often and they do tend to run when the system is peaking, I think that may play into what kind of costs they can bid at. But I don't have much more on that. The commission really made the policy judgment based on if we've allowed it in the tariff, we don't see a basis to exclude it here just because some combustion turbines that have great access to gas supplies may have a competitive advantage in the real market, but for the hypothetical resource, the commission just chose not to make the assumptions about that.
Okay, thank you. Let me make sure my colleagues don't have additional questions for you, Ms. Spanta.
Not me.
Okay, thank you.
Thank you.
Ms. Spanta, we'll hear from Mr. Flynn for the interveners.
Good afternoon, Paul Flynn, on behalf of PJM Interconnection. Starting with the 10% contingency, let me refer you to JA 33 and 34, which is where you find the tariff definition that was modified to insert the 10% rule. And what you will find there is something called peak hour dispatch. And peak hour dispatch is an extensive set of rules to set administratively when this hypothetical generic combustion turbine plant will run and sell energy. And as you can see, there are quite a lot of standardized and simplifying assumptions to capture that hypothetical circumstance for this unit. We're not talking about what anyone actually does in the energy market. We're talking about FERC setting some reasonable, standard, simplifying assumptions for when that hypothetical resource will run, like these 4-hour blocks and the 3-hour blocks and how often during the day. It's pretty extensive, and there are a lot of assumptions in there. My take is that FERC basically thought that, look, what mattered was, and this is what they said in their order, that what mattered was that other components of it, this is at paragraph 31 of the rehearing order, JA 401, other components of energy offers are already included in the energy offset estimate. And we agree that it is appropriate to include the 10% adder as well, since it too is a permissible component of energy offers. It's called an adder, but it's really to deal with the uncertainty that exists about, in particular, your fuel costs when you're making an offer in advance.
But I haven't heard you respond to the main question I have, which is, I mean, let's say it were known that combustion turbines bids into the energy markets only, less than 5% of the time use the adder. Would that not be material, along with the generic notion that it's permissible for them to use it 100% of the time?
Well, that is a hypothetical question. Evidence to that extent was not presented. And I mean, you could say 0%, you could say 100%, or you could say, let's get a lot more complicated about how this works in the context of this one subset of this.
Right, or
assumption.
let's just ask generally the combustion turbine owners, and if it turns out that it's something in between, wouldn't it be more accurate, and accuracy is what we're looking for here, wouldn't it be more accurate to say, let's put 50%, let's not put the whole 10%, let's put a weighted 10%, and we know that the economic logic is going to deter combustion turbines from actually making use of the up to 10% adder because it will make their already expensive energy more expensive. So why shouldn't it at least be, and we're not, standard of review, double deference, we read your briefs, but nonetheless, it seems like there's a logical, potentially dropping of the ball here. And I'm just looking at what your best answer is.
Well, FERC's rationale was as stated in their order. I guess the question is, how far on every one of these assumptions does FERC have to go to establish that what is overall the demand curve, that at the end of the day, it's the demand curve that is used to balance cost and reliability, is just and reasonable. And FERC did that in spades because we provided them ample evidence on that. And if you're willing, I'd like to turn to that next, if you'll give me the time to do that.
It just your time's expired, so I just want to make sure that you're addressing the particular question before you about the 10%. And I have one follow-up question, which is, do we know on the 10% if it's made use of, let's say, half the time, just as a ballpark? Do we know how much of an effect that would actually have on the demand curve?
I don't know that we have that data. And
would it be much?
I don't know how that would, I don't know what effect that would have on the demand curve. Again, it is not counterintuitive for a seller to say, I'm legitimately concerned about whether or not my fuel cost might be uncertain. And so I'm going to add that contingency in there. So that is not economically irrational. They may do that. But we don't have evidence and record of the extent to which that is done. Because again, FERC looked at it in terms of a permissible energy offer, a maximum energy offer that they would permit would include these factors, which is the type of analysis they do in other cases in the capacity market in terms of what's acceptable.
Do we know, Mr. Flynn, if there was 10% or zero, if the 10% adder were disallowed? We do know how much difference that makes in the demand curve. Do we not? I mean, it's not the 100 million that Ms. Roberts has been.
No, certainly
it
not.
has to do with the choice of reference resource. But if we're just talking about the demand curve, the change in the price based on including the 10% in the net cost.
I'm not sure, Your Honor. You would, again, it's a modeling effort specific to the peak hour dispatch, because you're saying under this entire set of assumptions, if you also assume that they do not have this extra bit in their offer, what happens every hour of the year in terms of how they clear in the market? It's not a simple calculation that you can just do the math and say, oh, it's this. You'd have to run the model.
Right, they're only in the market a very few hours in a year. And we have presumably past performance information. Well, maybe we can ask Ms. Roberts when she's back before us. But yeah, it would be helpful. I mean, if the chief is not averse to have you talk about the first issue as well.
I would love to. And again,
why don't you just take a minute to do that?
Sure. Could I draw your attention to, it is Joint Appendix 189, which is Brattle's report on the demand curve, through table 11. This is what you were referring to earlier in the argument, Judge Pillard. Brattle does Monte Carlo simulations that look at 1,000 different slightly varying scenarios and come up with an average and a projection for reliability and for cost. And they do that, in this case, for 6 different curves. 2 of them were existing curves. So really there's 1 combustion turbine that was new and 3 combined cycles that were new. And if you made it to that table, if I could draw your attention to the 4th column in from the left, which is where the costs are.
I'm sorry, tell me again what page you're on. I don't think I'm on the right.
189.
189.
Thank you.
So when you get to that table and you look at the cost column, which is the 4th set of numbers in, you'll see a very tight range of costs. It's on the order of 7.9 billion to 8 billion, more or less. Captures all of the different curves that were considered. And specifically, the curve that FERC approved is B as in boy at 8.06 million. And the curve that petitioners have advocated is D as in David, 7.97 billion. So for costs, we're talking a difference of about 1% in these Monte Carlo simulations of future costs and future reliability. So we're not saying, oh my gosh, they're going to pay an extra $90 million a year coming out of someone's pocket. This is a comparison of modeling scenarios. And there's only a 1% difference between the two. And then you look over to the column which is second from the right, and that shows a number of percentages for the different curves, including how frequently each of those curves is expected to produce a result below the reliability requirement. And you see for B, it's 0%, and for D, it's 5%. So there's a bit of a difference there. There's a bit of a difference which is adverse from a reliability perspective. If you look at the column that is called average LOLE, it's like in the middle. And then stress LOLE. Stress LOE says, what if it's like stress testing anything. What if one of our assumptions was off by a bit? You'll see that of the 3 combined cycles, which are the last 3 numbers, 2 of them are above 0.1%, which means they violate, on an average basis, the expectation that you'll only have 1 loss of load every 10 years. So as a group, the CECs clearly do worse than the combustion turbines. So what does FERC have to say about all this? FERC says, and when they briefly note in their opening to the discussion of the VRR curve, which is where this appears, all this stuff about the cost of a combustion turbine versus the reliability of a combustion turbine in a combined cycle, all appears in FERC's discussion of the VRR curve, not of the reference resource. But that's where the numbers of $100 million that petitioners have cited, that's where that comes from. So FERC, in that brief introduction at paragraph 17 of the initial order, notes PJM's statement that all of the annual cost projections were clustered fairly close together, with the total customer cost difference over all curves ranging only a few percent. That's one of the few facts they cite in that opening. And then they say in paragraph 16, PJM's proposed changes result in a curve that meets PJM's reliability needs at a reasonable total cost to load, which is the numbers we were just looking at. And then similarly, in paragraph 20, the J301, FERC found that PJM's analysis was sufficient to meet the requirements of its tariff, which is designed to ensure the proposed demand curve meets PJM's reliability needs at a reasonable total cost to load. And we know they were talking about the Monte Carlo simulation model when they say that, because in the very next breath, they say that the public interest entities, which is the petitioner group.
Let me ask you, Mr. Flynn, because I know we're over time, and
sure.
Just going back to the 10%. So PJM didn't actually investigate the issue before adopting the adder, right? I mean, Brattle had said it's sort of difficult to study, but it might be a good thing for further investigation. And that PJM chose not to do that investigation, right?
It was more of a normative call on the basis of this is an element of what people can offer in the energy market, and you shouldn't just exclude it. And so we included it.
Right. And there was no reasoning in so doing that making a more fine-tuned factual judgment was going to be too difficult and too much of a going down a rabbit hole. It wasn't like, well, it'd be great if we had that information, but we, on balance, decide that it's not going to be worth the candle to do that further investigation. It just was like, this is permissible and that's enough.
Yeah, I don't know that there was a sense that they said that it would be very easy to make that determination. I don't think that.
No, they didn't. They said that it's a little tricky, but maybe it's worth further study, and that was not taken up by.
That's what Brattle said.
Yes,
yeah.
Right.
But I don't know that PJM said no. It's not worth it.
Exactly. Didn't say that. Just said it's authorized, and therefore we're going with it.
And it's better to include it than not. And so it was proposed to be included, and FERC accepted it on that basis as part of a lawful offer in the energy market, which is a rational sort of approach.
Okay. All right. Thank you. Let me make sure my colleagues don't have additional questions for you, Mr. Flynn, this time.
No.
Thank you.
Thank you.
Ms. Roberts, we'll give you your 3 minutes for your rebuttal, please.
I appreciate it. Thank you, Your Honor. So I first want to pick up on the 10% adder issue briefly. You're absolutely right, Judge Pillard, that we don't know how often the 10% adder is used. And FERC has a tool at its disposal to get more information in these kinds of situations. It can issue a deficiency letter to PJM to ask them to submit additional information. FERC did that on a different issue in the case, could have done it on 10%, but I think just decided that that level of accuracy wasn't important, didn't use the tool at its disposal. And this whole 10% adder issue, which as you've noted, can affect this assumption, this single assumption can affect the energy revenues that are earned by the reference resource by 1/3, just shows why it's hard to estimate the cost and revenues of a combustion turbine, and one reason why it doesn't pass muster under that 3-part test. And Joint Appendix 141, Brattle discusses these uncertainties about gas procurement costs being one reason why it's so hard to determine the costs and revenues for a combustion turbine resource. Next, I'd like to just touch on the evidence that Mr. Flynn was discussing with this table in the Brattle report showing the frequency below the reliability requirement. I want to stress that FERC has said that that reliability requirement must be met on average, not in every single year. So the column he was pointing to about this is the percentage likelihood below the reliability requirement is on an every year basis, which is not the standard that FERC has set. And this goes to something that Ms. Banto was saying. Of course, FERC can allow rates to increase to ensure reliability, but it needs to explain why it's doing so, and it needs to be specific. So if FERC wants to depart from its prior determination that the reliability standard is 1 in 10 on average, I suppose that it could do so, but it would need to do so consciously and explain why the additional costs that are being imposed on consumers are now necessary in its view, rather than adhering to the previous formulation of the reliability standard that it's established. And finally, I want to note that the language quoted by both Ms. Banta and Mr. Flynn about FERC's consideration of cost is really lip service to this requirement that they look at the cost. Simply saying the word cost or this is at a reasonable cost does not meet the requirement for reasoned decision making, where very specific arguments have been made in a request for rehearing that the specific costs are not worth the sort of specific incremental reliability benefit that consumers would receive. So FERC just didn't ever talk about what's the incremental reliability benefit of sticking with the CT, what's the incremental cost associated with that, and make an express decision that that cost was worth that cost. So just generally referring to this is at a reasonable cost doesn't pass muster. So that's all I have. We respectfully ask the court to remand the FERC orders in question based on the flaws in the orders that we've noted in our briefs. Thank you.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Thursday, April 8th at 9:30 a.m.